thank you very much for coming along to this event. So we have a panel discussion and a workshop to follow. The title being Doing International Economy Law Differently, Socio-Legal Methodologies and the Study of International Trade, Investment and Financial Law. So we have Markus is going to be chairing our panel discussion at the moment. He's going to introduce speakers and talk about that aspect of the afternoon. Just before we get into that, I want to just welcome everybody, say thank you very much for coming, and first of all just ask people to introduce themselves if they can, so we know who everyone is. Now, in the second half of the session there'll be an opportunity to talk in smaller groups about your research interests. So for now, I'm just asking people if they could say who they are and what institution they're from. That would be great. Celine, can I start with you?
Yes, I'm Celine Tan. I'm an Associate Professor at the Law School here at Warwick. I work on IEL and developing, focusing on international development finance.
Hello everybody, I'm Yunxiang Xu. I study in Birmingham University and my area is about energy law, and I'm very pleased to meet everybody here. Thank you.
Hello, my name is Lilian Wan. I'm from King's College, and I'm currently working on transnational law and global governance.
Hello, my name is Lorenzo, as well from King's College. I'm a representative on corporate governance and a case studies column.
My name is Uche Naguma. I'm from Durham University and I'm currently interested in international investment law.
I'm Jenny. I'm from Jenny Lennox. I'm from the Law School here at Warwick. I'm just submitted my PhD, which is about the constitutional implications of foreign direct investment in affiliates minor.
Hello, I'm Chris. I'm currently enrolled to the postgraduate degree with International Economic Law here at Warwick. And hopefully I'm going to be a PhD student here at Warwick at the area of International Investment Law.
My name is Alison. I'm studying sustainable development and waste management.
Sorry, which institution?
Okay, sorry, can't ask it.
My name is Rosanna Blanc, and I'm a lecturer at the University of Leicester, and I do mainly United Nations law, international law.
Hi, I'm Mary Pure. I'm a PhD student here at Warwick, and I study international human rights law and corporations.
I'm Sundu. I'm a PhD student here at Warwick. My area of interest is financial service regulation.
I'm Julie. I'm helping organize the elections.
Future PhD.
Yes. It was such a modest.
I'm Claire Williams. I'm from SOAS, and I'm on the home straight of a PhD at the moment, looking at an economic sociology of law approach to foreign investment and World Bank doctrine.
My name is Markus Wagner. I'm an Associate Professor here at Warwick, and I teach in mostly international economic law related areas, focusing on trade and investment law and the intersection of those.
Hello, my name is Lorenzo, Cotula. I'm a principal researcher in sustainable development law, sustainable development at IIED, which stands for International Institute for Environmental Development Policy Research Institute based in the UK. And I'm also a visiting research fellow here at Warwick Law School. I'm interested in international economic law and particularly investment issues.
Did I say about me?
No.
No, you did. Well, my name is James Harrison. I'm also at Warwick here, and I'm interested, as I say more about at the moment, in various aspects of international economic law and its intersections with other areas of law, human rights and environment in particular. So, thanks very much for introducing yourselves. As I say, in the second half of the afternoon, for those who stay for the workshop, we're going to split into small groups and there will be a chance to talk through your own research interests in a lot of detail. We hope that the first half, the panel we're going to have now, is going to stimulate you to have all kinds of interesting thoughts that you can then take forward and discuss in the smaller group that we'll do later on in the afternoon. We don't promise to have the answers to all of your questions, but we hope to kind of stimulate you to think through some of the questions in a lot more detail. And then after we finish at around 3:30, what we thought we'd do is just take everyone over to the Dirty Duck, which is a pub on the campus, buy you all a drink, and leave you there to have a chat amongst yourselves, in the sense that we've got people here from Birmingham, Kings, Durham, Kent, Leicester, and Warwick. Probably have someone else. But that you're all working in your own institutions, and to come together as a group of people who may have similar interests, and then have a chance to talk to one another, and maybe create networks that might help you through your PhD process later on might be quite helpful. So that's how we will end things, I hope. Hi, come in. We're just introducing ourselves at the moment, so I'll let you sit down. I won't make you introduce yourself while you're standing up, that would be. One final thing to say before I hand over to Markus then, which is we're colleague Helen from the Law School of Warwick is very kindly videoing the event for us. The reason why we're doing this is because there are lots of people who want to be here who weren't able to be here. So both people in the UK will actually be advertised at the Society of International Economic Law and Markus help internationally, and there were lots of people who were interested in knowing more and getting an understanding of what we were doing here today. And so we wanted to do a video that we could share with them. So we hope that's okay with everybody. To the extent that people don't want to be included within the video, if you could just at some point tell Helen that you don't want to be included, okay, and then we'll edit out at the end you from the video. So don't worry if you think that the video, you can edit that out later on. Is that okay with everybody? That's the process going forward. So we hope that will be a helpful resource for people here and people who aren't here to have in the future. Okay? Great. Yes. Oh, sorry, yes. Could you introduce yourself? So we've been around and introduced ourselves, just said like who we are, what institution we come from, and just one line about your kind of research interests would be great.
Okay, thank you. Sorry for being late.
That's
so
fine.
my name is Yuan Chuang. I'm from Socio-Legal Law School. I'm doing my PhD in surgery.
Okay. My name is I'm from University of Dundee. I'm a PhD student in the Department of Politics and International Relations. My focus is on regional governance in West Africa.
And I think you've got the prize for coming the longest, furthest way. So thank you for making the effort.
Over to me. So you can see our title, right? Doing international economic law differently, socio-legal methodologies in the study of international trade, investment, and financial law. We try to keep this relatively broad within the field of international economic law. For better or worse, I will play the part of the traditional lawyer by providing sort of hopefully stimulating questions. I don't think I'm quite as black-letter lawyerish as I may come across in the questions, but I think they're meant to stimulate discussion, right? So we see, I think, more and more non-traditional methodologies in international law more generally, but also in international economic law more specifically. If you look at American Society of International Law, if you look at the European Society of International Law, certainly if you look at the Society of International Law, where I'm the co-secretary, we try to get people to recognize, at least with respect to SEAL, that is an open platform. Right? And if you look at the annual meetings of these three institutions, which I picked sort of at random, but not really at random, I think those are the three main loci where things are moving a little away from black letter law, then you see that there is some engagement with the question of, are the current methodologies really the ones that, or are they the ones we should focus on exclusively, right? And I think the answer is clearly no, and we'll try to show some of these non-traditional methodologies that I'll call them, and how useful they are, and what we can learn through them that we can't learn from looking at the books and one's own legal system has trained you to do. Right? So I'll throw the first question out, and I'll start with Celine maybe, and just say, sort of, what kind of research are you undertaking? So the first part is sort of getting to know where we're coming from, because I think that's actually important. because oftentimes people have sort of hidden, not fear, right, but oftentimes their methodologies sort of predetermine oftentimes the outcome. And I think you see this in particular areas. And so what kind of research are you currently undertaking? And I'll follow up with questions after that.
Yeah, so like I mentioned, thank you Marcus, like I mentioned earlier, my research focuses on primarily the intersections between international economic law and development, broadly conceived. So I tend to look at the impact of international economic rules and institutions, particularly international financial institutions, and their impact on development and governance issues within developing countries. And so within this framework, I specifically look at development financing, international financial regulation, sovereign debt issues, and the impact that this has on countries' ability to, meet sustainable development objectives and goals and fulfill their human rights obligations to their citizens. And that's sort of broadly, very broadly, the gist of my research focus.
Great, thanks for starting us off. And James, if I can ask the same question of you, we'll then go to Lorenzo, and then I'll start to sort of probe you individually more specifically.
Sounds dangerous.
Yes.
So I have a slightly longer answer, which just takes a bit further back in order to say a bit about my approach. So I started off not as a researcher, as an academic, but I was actually working in a sort of society organisation, and there I was looking at the impact. So I was looking at independent investigation of police complaints. And I was working with academics and they had to design methodologies, but what the UK was at a time when, people know Stephen Lawrence inquiry was happened, people are familiar with that, and we need independent investigation of complaints. And then it was, what does independent mean? How do we make that into practice from being this kind of idea? And so I was lucky enough to go off around the world and explore empirically what other police complaint systems look like, take that information back, look at other kind of investigatory systems and try and bring some of that knowledge and understanding in order to make proposals for how an independent police complaint system might work in the UK. So then I moved completely off that. I decided I wanted to, later on I thought that was great, I really enjoyed it after I not enjoyed legal practice. And I came and decided to do a PhD, and that was around the intersection of trade and human rights. And so I spent 3 years doing that. And the following 4 or 5 years of my career probably, looking very much, in a sense, in a black letter law way, at the intersections between trade, investment law, human rights, environmental law, business activity in that sphere as well, and trying to understand what the intersections between these areas of law were. And so I found myself kind of trapped within a paradigm, I thought, of how those debates functioned, which is primarily a legal paradigm in which the idea is to try and find primarily coherence within that system. So that there are these branches of international law and they intersect with each other, and as lawyers our job is to kind of make sense of this seeming incoherence and provide some coherence to it. And I wrote an article in the London International Review of Law a couple of years ago, which almost reflected on that first kind of 5 or 6 years of my academic career and argued why I find it, I suppose, inadequate and why I didn't think it was answering the right questions or asking the right questions. And so that brings me on to Markus's question, which is, so my research interests now are very much more focused on what the impact of international economic laws are on broader social processes, I might say. So I try to move from looking at law and the legal systems and the internal dynamics of them to trying to understand what the impacts of particular laws are on that external world processes. And that's, I suppose, why I would move to describe myself primarily as socio-legal. And that's meant that the 2 areas, I'll talk about one of them more than the others today. First of all, about the human rights obligations that multinational corporations take on, and trying to understand whether those are meaningful in the world outside the statements that are made by those corporations. And the second project I'm working on at the moment is around EU trade agreements, and EU trade agreements contain, as a standard part, trade and sustainable development chapters. And so trying to find out, well, what are the effects of those trade and sustainable developments in third countries. So instead of arguing about environment and human rights and labour and how they are coherent with or not coherent with trade law obligations, trying to say, well, these things exist within trade law, these obligations, what are their actual impacts on the outside world?
Great. Lorenzo, if I can ask you the same question, and maybe also start to address why some of what we call traditional methodologies just don't cut it for you, just are not sufficient.
Yeah. Okay, so I mentioned I'm working in a policy research institute, and in the context I work in, doctrinal analysis has an important role to play, but we think trying to engage with policy and practice also requires an understanding of how the law is working or not working in the real world. And that really leads us naturally to a sort of socio-legal take on the issue. Now, personally, I'm primarily looking at investments in natural resources sectors in low and middle income countries, which sounds quite specific, but actually it's an entry, it's an arena that opens up lots of different areas of law and interactions between them. So within international law, you have international investment law, there are important human rights issues, but there's also the interface between the international and the national legal systems under which rights to resources, for example, are allocated to commercial operators. There may be issues on the ground in terms of grassroots impact and responses to investment processes. So it's an arena that really does open up a significant complexity in terms of understanding what the issues are and what the legal dimensions of those issues also are. And we've been, one thing that we've been trying to do in that space is very much work with, combine the legal analysis of text with working with partners or partner organizations that are based in the country that can actually help us better understand where the legal issue sits within the context that is quite often political, economic, and so on. One piece of research I was hoping to draw in particular for the discussion today is a report we just published a couple of months ago titled China-Africa Investment Treaties Do They Work? Now this, just by way of recap, reminder, or very brief intro for those who are not very familiar with international investment law, essentially the international investment regime is very much structured around a network of about 3,000 bilateral and increasingly regional investment treaties that essentially promote or aim to promote foreign investment, primarily through investment protection. The idea is that if you protect investments, more investors will go in and invest, but also increasingly investment liberalization. And then there's been quite a bit of debate of late around the notion of investor-state dispute settlement, so the notion that investors will be able to activate these protections, including in treaties, through actual legal proceedings at the international level, essentially suing states and seeking compensation from states. Now, I think this has been a huge area of international legal scholarship. There's a lot of doctrinal work that has been published over the years, looking at the treaties, looking at how arbitral tribunals have interpreted the treaties and critique thereof. And I think that is very useful. If I look at it, though, from a policy perspective, what I would want to know also is, before looking at specific formulations of investment treaties, alternative options for formulating investment treaties, a key question is, should I sign the investment treaty? Should I start negotiating an investment treaty with another country? And I think that really opens up a set of questions around the costs and the benefits of investment treaties. What do I gain as a country? And what do I give up as a country as part of that? And so that's where we'll actually frame this research, is that the key benefit that is quite often identified is that if you sign these investment treaties, you would then attract foreign investment, and that foreign investment would promote economic development, and you would have a number of other benefits. And we thought that actually to operate in this sort of policy space, one would need to interrogate that set of the chain of relations between the treaty, the investment, and the economic development. And so that's what we did with the study. What was quite handy for this piece of work was the fact that the governments of China and African states meet on a relatively periodic basis. Every 3 years they have what they call FOCAC, the Forum on China-Africa Cooperation, that releases a statement. And the statement of the past few years have consistently issued included paragraphs where they said we want to sign these treaties because we want to promote foreign investment in the context of South-South cooperation. There was a clear policy goal that was stated, and we wanted to test it out. And so, in a sense, to go back to the second part of the question, why is it? What do we think? Why do we think with the trial analysis that only goes so far? Well, we thought that in this context, the trial analysis was actually very helpful because we wanted to interrogate the treaties themselves, the text in a sense, in terms of legal analysis, to see whether there are substantial differences, for example, from the conventional North-South treaties, and so whether this notion of South-South cooperation has an actual bearing in legal terms. But we also wanted to investigate whether the treaties are actually promoting the investment that the policy goal refers to. And for that, we couldn't just rely on reading the treaties. We needed to find a way of looking at whether the investment is actually flowing in. Now, we can discuss perhaps later, there are different approaches, different people have tried to look at that. The path we chose for doing that was to actually interview a number of companies, Chinese companies, and also experts that are advising those companies, are following the industry, and we've been asking them questions as to the extent to which they actually consider the existence or otherwise of investment treaty in their investment decision-making process. To do that, I couldn't do that on my own. I don't think I would have any response, so the report is actually jointly authored, 4 authors and also 2 institutions. We partner up, work closely with institutions based in China. And that was really instrumental to them making it possible in terms of being accessing the interviewees, as you refer as the Chinese. I'm not sure whether we have a chance to actually talk about research findings, but in a nutshell, we found that we found essentially a cautionary tale as to whether investment treaties do promote investments, insofar as most of the companies we spoke to had never really heard about these investment treaties, which then feeds back to the policy space as to, so if this is not what they want, what it is that they're actually interested in, what it is that is creating a bottleneck for them to invest, and we need some work on that as well, and make some policy recommendations that affect.
Great. So you've identified sort of one area that seems to sort of predate the traditional sort of interpretation that lawyers tend to do, right? Not when the dispute arises, but prior to that, right? What are the costs and benefits? I mean, usually we tend to leave that to the economists, right? And I'm not sure that's the right approach to take, frankly. But so that's one way. Can I throw the same question to both James and Celine? Why in your areas are some of these more traditional methodologies not sufficient, or where do you see sort of scope for application that really brings a benefit to...
I'm not leaving, I'm just... I was hoping you were just a slide to help me.
Brings a benefit to better understanding of what's going on.
Yeah, so James's slide actually is taken from this book. It's, some of you might have heard of it, some of you might have used it as a Bible. It's Socio-Legal Approaches to International Economic Law, Text, Context, and Subtext. And it's actually a book that was born out of a panel of discussions at the Socio-Legal Socio-Legal Studies Association annual conference in 2010, I believe, and Amanda convened a whole bunch of us who did contextual socio-legal type work on international economic law, and gathered us together and talked to, asked us to kind of like approach IEL through the lens of socio-legal methods. And it was actually the first time that I sat in a room full of lawyers and thought, oh, well, these people understand what I'm talking about. I just kind of, felt, I was like, oh, wow, you go to these law conferences, and sometimes I kind of feel a fish out of water because I go to a non-law conference and I feel like a fish out of water because I'm a lawyer. And I go to a law conference and I kind of feel like a fish out of water because I don't do doctrinal law, and you're nodding your head because you understand how I feel. And so I wrote a chapter, which I've got copies of if you're interested in taking away, on basically what I thought was the limitations of traditional international economic legal scholarship and in mapping international economic law. And I think I'm going to draw on some of those issues to sort of answer Markus' question about the limitations to my research. First,
we'll get to that later. The limitations.
No. Limitations of traditional methodologies to how I would approach my research. And the first one is really that I think that traditional international law methodologies fail to basically capture the essence of what international economic law is today. I mean, you've got multiple fora for international economic law that don't quite sit very comfortably in that international legal scholarship categories. So it's moving sort of like from hierarchy to polyarchy. This is Sol Picciotto, again one of my influences, term, that it's, IEL is not just about, state law and having, interstate actors, which is the traditional conceptualization of international law, which I find quite limiting. It doesn't capture the fact that a lot of international economic law stems from non-traditional sources, non-state actors, that we've got a lot of soft law, particularly in my area of international financial regulation and also international development finance. A lot of these, the norms that control the behavior of state and non-state actors within the system isn't sourced from what you would consider the traditional sources of international law, of treaties and customary international law. A lot of it stems from so-called soft law. So these traditional normative categories of hard law, soft law, state law doesn't quite apply, because we know that from international financial regulation that a lot of the norms that constrain the behavior of state and non-state actors within the system isn't derived from what we would conceptualize as conventional sources of law. It comes from the Basel Committee on Banking Supervision, it comes from the IMF, and a lot of these are soft law recommendations. Credit rating agencies have a lot to constrain the movements and the actions and the activities of financial actors. So in that sense, that is one of my limitations. The second limitation, I think, is that international economic law, traditional methodologies of international economic law, don't actually look at the constitutive role of law, which is a very socio-legal concept, that law isn't just a reflection, it isn't a way of governing society. It reflects how society wants to be governed. So law is constitutive of the modes of production and consumption that we have today. It's constitutive of how we want to see societal relations. So it's not a neutral arbiter, right? And I think the formalist theories, which sees law as something that we have to analyze through a textual and interpretive analysis of international rules and how international institutions work, I found that very lacking in terms of how I saw law, because I always saw law as a reflection of how society wanted to govern, and that's, in as much as it governs society, it itself is governed by society, if you get what I mean. So I thought that was very problematic. And the third, which is the most important part for me, why I kind of felt that traditional international legal scholarship failed in terms of helping me develop my research, is that I think international law, as we know it from a doctrinal perspective, fails to incorporate these analyses of the contestations of power that is within the international legal system, that certain actors have power, more power, and they use that to influence the norms of behavior that and the development of international law, particularly when you look at the history of international economic law. So I think for me that is very central, because for me I want to study who's behind these rules, why are these rules made in this way, why does it disadvantage certain groups and privileges others? And you can't get to that if you don't analyse the power dynamics that reside behind international law, behind international economic law. So that's sort of where I'm coming from.
James? So, yeah, building on what Celine said, I think I'll refer to the slide behind me and say just if I think about the project, I was going to talk about a little bit about looking at trade and sustainable development chapters within EU trade agreements in order to exemplify some of the issues that are up there. So if you think about that project, then if the traditional legal methodologies would be concentrating on the text of those sustainable development chapters, right? Within the text of wider trade agreements, and maybe with the text of other international legal documents or national legal documents. And looking at the interplay between those, and looking to see if they look coherent as a whole, looking at if there are inconsistencies, incoherences, problems, tensions, and looking at the way in which they may have been interpreted by various different actors, sometimes judges, or where you might have other forms of amicus briefs or whatever that might help us. But it's a textual analysis which focuses on what the law is. And then if you look at what I set out in that chapter in a lot more detail, briefly set out on that slide, if you look at context, then you start asking questions about, we were talking about this before we started the session, what would be the historical context behind the law, understanding why and how it developed, which allows you to ask to see the power struggles that underlie why the law came about in the way it did, who was influential in bringing it into being, and that tells you a lot about why the law looks the way it does. And then, my primary interest is understanding what the impacts of that law are, so what effects do trade and sustainable development chapters within EU trade agreements have in the countries that sign up to these trade agreements. You then have to look at how the textual obligations give rise to practice in the countries that are participating within that trade deal, right? So you have to go out and understand what practice that gives rise to, and that for me has been by talking to actors who are engaged in the institutions of the trade agreement, not just in the EU, because a lot of that research tends to be very EU-centric, but primarily starting with the EU's trade partners and investigating what their perceptions, knowledge, understanding of the impacts of that process has been. So analytically, so the how do you go about doing that? I'll say a bit more about it. My approach is very much a problem-oriented approach, and I'll talk about later on. But that means I want to be thickly informed about what that problem is by a range of different literatures. I'll leave it at that now, because we're going to come back to that. Empirically, it means I've got to go beyond looking at legal texts, because I want to understand facts, and facts that aren't just within the legal system about what the legal system and what the legal obligations are, but facts about how those legal obligations affect societal relations beyond the trade agreement itself and the countries that are participating within that trade agreement. So that requires me to go beyond traditional scholarship, which would limit me to those kind of questions. And normatively, I think it allows me then, by adopting those kind of methodologies, to both provide a clarification of what the aims and objectives of a trade and sustainable development chapter are, what is it actually trying to do, clarify those kind of issues, and then potentially to challenge my understanding of what I found out about what it is doing. So a challenge that comes not from within law itself, but within an understanding of the way that law is constituted in the different societal settings that Celine was talking about before.
So let me take a small pause, right, and just sort of lay the landscape a little bit of what different approaches I think one can identify if one sort of thinks about it, right? And we'll talk about this. So everyone, I don't think I need to sort of explain what the doctrinal approach is, right? We've all been inculcated by that through your legal studies. I think that's probably true for every legal system that I think I've heard represented. I'm German myself, so I'm deeply embedded in that. And I think there's a great amount of utility for it, but I think there's more to be said on other areas, right? So I think if you look at it sort of empirical approaches that one can identify, we talk about socio-legal work. We've certainly slash law and society. I've never quite understood what that exact difference is, right? Then we certainly have law and economics in its different guises, and there are certain utilities and also limitations, and we'll talk about limitations as well. Problem-based approaches that both James and Lorenzo, I think, have introduced, and then we somehow also go into schools of thought that are somewhat different, right? In terms of methodological approaches that one can identify, like 12 third world approaches to international law, critical legal scholarship, and Celine has already alluded to this, that there's an uncovering the power structures that undergird all of this is an important part of that. My question, sort of now I'm putting on my black letter lawyer hat, right, is, look, law is, I say smirk on my face, right? Law is completely neutral, and you trail people and the critical legal scholarship people have your own agendas that you at least need to confront, right? Or at least lay open. And my question then is, what are the benefits but also the drawbacks of these different sort of strands? And I made no claim that this was a complete version of what's out there, but I think those are some of the most salient sort of schools of thought that are relevant for international economics. Any of you take it away? Shorter answers appreciated, and then we'll just go into a conversation about it.
So I would say that part of my way of dealing with that is to frame my problem very carefully. So I say I'm a problem-oriented approach scholar. So I identify what the problem is that I am trying to investigate, and then I frame that problem openly from the readers of the people who read my articles, and more importantly for me, the way that I then conduct my research. So if my problem is, in the research project we're talking about today, what kind of effects do trade and sustainable development chapters have in trade partner countries that have signed up to those commitments, then what I want to understand, first of all, is what were the intentions of the various different actors who are trying to get these trade and sustainable development chapters into those agreements. And then, in a sense, those become the things that I'm interrogating to find out if they happen in reality. So there's a sort of an understanding of the intentions behind those chapters, and that, in this case, is overlapping. There are lots of different actors with lots of different intentions, and so that process of understanding why the trade and sustainable development chapters come into being and how it's supposed to achieve effects actually tells you a rich tapestry in itself that means you should write an article that you never thought you were going to write. But then, in understanding, and then in thinking, well, how do I investigate what its actual effects are on the ground? And this is why I come back to being a problem-oriented scholar, as I would call it, is that I then want to read widely around literatures that might inform me as to the kind of questions I should be asking to get to the root of those issues.
So let me interrupt you right there, right? So to what extent does the problem-oriented approach, right, potentially have, we'll talk about this, but let's broaden now, right? What are the limitations thereof, or what are some of the issues that people should be aware of when engaging with it? Because someone could very quickly say, yeah, you're looking at a problem, but that problem may exist in this particular context only and not in other areas, and what conclusion should we draw for a legal system that needs to have answers to more than that particular issue only, right? I mean, that's a perennial issue of law, right? What do we build our legal rules on, right? Do we build our legal rules on, the classic example in the US, video cassette recorder and rentals in the 1980s and privacy issues? Or do we want to think more broadly about what that means for other areas of law?
So I think the only way to kind of rebut those kind of challenges is to be open about the problem that you're trying to answer, and then to get people's critique of that and whether that problem is meaningful. So the fact that there are claims made about what trade and sustainable development chapters should be trying to achieve, and then the fact that you can then go out and analyse what they are achieving on the ground, I think, to me, gives you some kind of meaningful entry into the debate about the place of these legal instruments within the bigger legal forms, but also the place of these values within the kind of legal institutions and processes that you're interested in interrogating. As a scholar, that then leaves me, I start with the reality of what is happening, and then I go on to talk about what should be happening. So I then think about how trade agreements should be constructed to take these values more seriously, but the starting point is that kind of empirical inquiry, which I think then hopefully gives me insights that are, I'll come on to that later, of interest to both scholars and policymakers in relation to the legal kind of constructs. I think the crucial thing from a more scholarly perspective in a way is then, as I said, as I was going to say, to engage with a range of literatures that enables you to have a thick conception of what the problem is. The problem can be constructed in a very narrow trade law way, where this is a set of legal obligations And the question is, how are these disseminated out to various different actors? And then law might have a series of processes. It talks about soft law and networking and a series of terms to describe that. And then my experience has been that working with people from other social sciences disciplines, they have other ways of describing those processes. So the political scientists I'm working with will talk about the EU externalization literature, and that will have another way of describing these kind of problems. And by engaging myself with that literature, it uncovers for me a whole range of other issues I should be looking at. Feminist scholarship, for instance, makes me think that when I'm looking at labour standards within these trade and sustainable development chapters, the traditional approach would be to look at waged work in those particular countries and the representation of waged work, but do we want to have a look at informal work and the degree to which that within labour standards provisions in EU trade agreements, that is captured within the kind of paradigm.
Well, wait a second, right? So I want to have a conversation, right? That all sounds great. But it also sounds, number one, very complicated. And number two, complicated to do, and complicated to explain. And for my black letter lawyer alter ego says it has absolutely no, it cannot give me an actual answer to a legal question that I need to solve.
So it depends on the legal questions you want to ask. I mean, so if the legal question is,
and the question by the way goes to everyone, right?
What do these norms look like? How do we characterize them? What form do they take? How do they interact with other forms of law? Then probably the answers, I'm not going to have very good answers for you. If the question I am posing is what is the effect of this law? What does creating these legal obligations mean for the way that actors behave in these different places? Does it change anything beyond the legal system in terms of the institutional setups in these, both within the institutions that are created by the legal agreement itself, so all these institutions that are created that do things, and that is supposed to filter down into national legal systems? If we can answer the question and say, we thought it might do this, we had the sense that these processes, that these norms would create these processes of dialogue that would achieve this at the national level, that was in some sense what we thought might happen. But actually what we found out is it's done this instead, which is completely different. Those look like answers to questions that can then inform the design of legal systems in the future.
Celine, you want to?
Yeah, I think for me, and I come from a slightly different place from James. I appreciate the problem-solving approach, which I actually do. I do see a problem. But for me, I try to sort of uncover the underlying factors behind that problem in a way. I'll give you an example. I was asked a few years back to attend a very doctrinal workshop on investment law, which Markus Wagner Law, and it was a very prestigious series of workshops. One of you might have heard. It's organised by Stephen Shaw. Some of you know him. He's a brilliant scholar, very, very good. But the workshop was very much a sort of very traditional, what I would say, black letter type workshop. And in this particular year, they were organising it around the theme of investment law and development. And they asked me to come in and speak to the notion of good governance in investment law. And so I looked at it and I thought, I bet you they're asking me to say this about investment law, which is that the traditional notion that investment law facilitates good governance in developing countries, because there is a natural trajectory that perhaps it will then get developing countries to buck up their legal systems and to provide more stability, predictability for investment lawyers, and then that has a trickle-down effect to the governance systems in developing countries for other citizens within that country to be able to have a legal system, to be able to mediate their disputes in a very predictable and stable manner. And that is also, that kind of trickle-down approach is also slightly contextual. So I'm not actually saying that, we're all presuming here that we're talking about social legal study approaches from a particular ideology. And of course, Some of us might have that particular ideology. I mean, you know, a sort of structural Marxist ideology, or a leftist or progressive, liberal progressive ideology, or a, you know, environmental kind of like dimension to a progressive ideology. But no, but sometimes, you know, you can be contextual, you can be socio-legal, but have a different, you know, come from it from a law and economics perspective, which is very, very different. It's a very, very different method of looking and analysing the law, which is not a traditional doctrinal interpretive analysis. So this is one of those. There's this argument that also went, you know, well, you know, if you look at this is what international law does, international investment law does. For me, I looked at the term good governance, I thought, hang on a minute, let's deconstruct the term good governance. What do you actually mean by that? Because the term good governance, which has been applied to investment law, has its own legacy. It has its own problematic birth, I would say, if you look back at the history of the concept that's been developed by the World Bank. And those of you, like Claire, for example, I know, worked on the World Bank. Those of you who are familiar with the World Bank will know that the World Bank has a particular conceptualization of what it means to be good, what good governance means and what the rule of law means in the context of economic relations. And it posits a certain form of socio-economic organization within developing countries that is highly problematic, that is premised on externalization of trade, of decentralization, deregulation, liberalization, etc., and also the institution of private property rights regimes within those particular countries, and good governance is seen in this one. So for me, I approached it at that level. And socio-legal methodologies, and I used a very discursive methodology to understand and unpick it, and basically go back to looking at you know, where did that concept come from? You know, where is the origins of the concept of good governance, and how is it used in the terminology in the text today? What is the subtext, in effect, of you know, in this kind of like what Amanda Casares calls the text, context, and so on? What is the subtext of the term good governance, and how is it used in international investment law literature today and in practice? Because if you put that into, if you actually talk about it and you put it into practice, for me, there is a move towards reforming the system, to rehabilitating the international investment legal system, to make it more palatable to the opponents of the system. And one of this, I feel, is using the term good governance to say, well, we can do this that has positive effects, so it's rehabilitating it, but reforming it in a sense to say, well, actually, we can reform the system, let's add some participatory mechanisms to it, let's institute some transparency, and they have the Mauritius Convention that's recently come into force. That is about, you know, instituting more transparency to the international investment arbitration process. And we've also got these moves towards trying to get more third-party engagement in the process. So, you know, advocates briefs, etc., by third-party interventions within the arbitration process. And for me, that, in a way, does not solve the problem that is an asymmetrical system, that there are problematic, you know, structurally the system is flawed. And so by rehabilitating the system, you're actually reinforcing some of the asymmetries. That is my argument, and that's how I saw, you know, how, for me, how socio-legal methodologies helped to conceptualize these problems.
Lorenzo. Yes, I just wanted to add, maybe, it was been said so far, strongly resonates, but I think there's also, that there are also some specificities in terms of seeing the issue, approaching the issue from a policy research perspective. For me, I mean, in a sense, following from what Jake was saying, in terms of the problem-oriented approach, I mean, for us also the starting point quite often is identifying an issue that policymakers and practitioners are grappling with, and then interrogating that issue quite often then leads to the identification of more specific research questions, and the methodologies and the choices that we make in terms of methodologies will really need to flow from the research questions. So you may very well have a research question that lends itself to purely legal analysis, but there are also quite a few research questions that do come up that actually cannot be addressed only or even primarily through a legal trial approach. No, the question that the example I was bringing up before in terms of the whether investment treaties do promote foreign investment in the context of South-South cooperation, that's a research question that inherently brings in a legal dimension, but also requires some empirical investigation. If I try to sort of, I was trying to think of some of the different experiences I've been involved with in terms of socio-legal research, and there have been different ways to try and address these sort of more socio-legal research questions. One is harnessing theory in order to, when approaching the law. So I think quite often there is much that can be gained from interrogating the law, not just from a trial perspective, but also from an understanding of, and this speaks with what Celine was saying, some of the more theoretical underpinnings of what is at stake, and that in itself can then, and that can also illuminate the issues and then lead to policy conclusions that are different from those that would be reached just by looking at it from a legal analysis perspective. So for example, a piece I was recently involved with was looking at the relation between democracy and international investment law, and particularly ISDS, in investor-state dispute settlements. Again, an issue that has formed the object of huge debate here in Europe and also elsewhere, where as the European Union was negotiating various substantial treaties, CETA, and the proposed TTIP, etc., etc. And I think there are, one could dive into that sort of issue from a purely legal perspective in terms of understanding what democracy is, essentially a system of governance that is structured around periodic elections, a certain features of national constitutions, etc. But actually, democracy means a lot of other things as well to many people. If you go and talk to people in the street, perhaps the legal notion of democracy is not the first one that we come up with. It's about citizen engagement, citizen participation in public debate, it's about discussion. And there's quite extensive literature on this, and body of thinking that has gone into this in political theory literature. And I very much use that to then interrogate what are essentially legal instruments from that perspective. And that has had a number of implications for the research that I was doing, because one of the concerns, for example, that has been discussed in public debate is the so-called regulatory chill concern, whereby the threat of governments being sued by companies for action they've taken in public interest might effectively discourage governments from acting in the first place. There's an argument that is out there, and there's been quite a bit of sort of contention around it. But if you can look at it in terms of doctrinal analysis of what the treaties say, how arbitral tribunals have interpreted those treaties, and what space they leave for democracies to run their course. But it could also, if you look at it, it's also an inherently empirical question. Do governments actually consider the treaties when they are on the verge of enacting, taking certain actions? And so that really opens up a field for socio-legal investigation, and there are people who have done that. But also specifically from a democracy perspective, it's not only the government as the authority that one we need to look at to interrogate this question, but also how citizens, whether citizens are finding it more difficult to get governments to act upon their demands in relation to, or as a result of the essentially investment treaty regime. So it's no longer just looking at the government as the authority, the national level authority, but it's looking at the variety of different actors that are trying to influence in the democratic process and trying to do the decision making, and the ways in which international investment law is brought to bear in those contexts. So all of a sudden, by harnessing theory, you're looking at law, but you're also looking at law, how it applies in practice. And I found that, particularly for me, I found that really interesting in my own research, and also fruitful in terms of trying to understand the phenomenon. A second area that is, I guess, is closely related is this cross-fertilization between different disciplines. So, for example, we did some research recently looking again at the investment issue, but from a different perspective. So you have large-scale natural resource projects in countries, say in a country in Africa or in Asia, and you have people who are losing land or being affected by pollution, and they are mobilizing. And there are lots of activists that are doing what they call legal empowerment. So they're providing legal trainings, they are training paralegals, they are working with communities to try and get a better deal, essentially, from the situation they're experiencing. And so that is very much a way of harnessing the law in a situation in which there is an imbalance and asymmetry, which I think Celine mentioned before. And for us, I mean, what we've been looking at is, by working closely with those organizations that are on the ground, so actually, by the time that large investment has reached the village, lots of key decisions have already been taken at the national level, contracts have been signed, or framework treaties such as bilateral treaties have been concluded, etc., etc. And so, and those decisions have been taken place in a context in which there are complex relations between people in government. You might find all of a sudden that government officials may have an equity stake in the project, and that high-level politicians at the national level have become all of a sudden very proactive proponents of that project. And there is essentially a complex political economy that makes it very difficult for an intervention to succeed if you're only acting by raising legal awareness at the local level. And so through that, starting from that, we thought, let's see what the political economy analysis tells us in terms of being able, as an activist, to identify the levers, the pressure points that you can activate. And by doing that sort of analysis, we realized that it's very important to act at the grassroots, but at the same time, that needs to be complemented by a variety of other interventions at the national level and also at the international level, and we looked at some experiences in that space. So legal, but also cross-fertilization with other disciplines. And then finally, just one final word. The third area that I wanted to flag is interrogating some of the assumptions that the legal instruments reflect. And that goes from, I think, what Celine discussed in terms of understanding what the power relations are between the different players in the field, but also going back to this report, I promised I would go back to illustrate points, interrogating the assumption whereby if you sign a treaty, you get investment, if you get investment, you get economic growth, etc., etc. And so by interrogating the assumptions, all of a sudden you open up a new field of inquiry, which inherently is not just legal, but socio-legal, and that also has a direct entry into policy choices.
So all of you have mentioned a lot, but now I'm going to become a little critical again and say, what are some of the limitations of these methodologies, right? Are we just not happy as lawyers and should we move into the next building on campus and become social scientists, not at work, because school of law is of course part of the social sciences, but move into a different department within the same building? Should we, does law disappear, or does it just simply become a partner on top of activism? Because when you just mentioned, well, for activism purposes we need to, and my alarm bells go off when I hear that, right? Because one then wonders what the purpose is, right? That one does this, because there's a fine line, at least on the academic side, to be drawn between academic investigation on the one hand and activism on the other, right? I think that is a line that I'm not looking at you because I really like this report. I think you're doing this properly, but I think there's a fine line to be drawn between activism on the one hand and academic integrity on the other, right? So I think I'd like to hear a little more about sort of limitations and maybe speak to where that line is or how one straddles that line between one and the other, right? I think that danger, frankly, is inherent if we look at investment law, for example, by everyone, right? So I'm currently writing on exactly the topic that you've talked about, regulatory chill, and we're looking at regulatory chill with a co-author on exactly the issue of how the discourse in international investment law is shaping up, because someone yells on one side and immediately you have echo on the other side. No one talks with one another, but everyone talks past one another because of their substantive positions. So, anyone take it away?
Yeah, I agree. I don't disagree, actually.
With what?
That with the fine line between academia and activism. I would put my hands up and say that I have come from the activist world, in effect. I have come back, actually, to the law because of socio-legal methodologies.
So you didn't escape, but rather it was an entrance way.
Yeah, I mean, okay, so a little bit of my background, I don't know, some of you might actually, resonate, this might resonate with some of you actually. So I did my undergraduate degree, and I then said, when I graduated, I really seriously don't want to touch the law anymore, because this is really just so boring. I mean, I didn't want to practice it, I felt that, it was just too right, it just didn't fit in. Why on earth am I just looking at, these case law and how does it even relate to me? And it was so dry. And I thought, no, I'm going to do something else. So I sort of worked with NGOs. I cut my teeth in a women's group in Malaysia, and then I went on to do a master's in law and development. At Warwick, because I thought, okay, well that's not really law, is it? They're looking at development stuff. And it was because of that particular cause that drew me back to the law. And if you told me 20 years ago that I would be sitting here, an associate professor in a law school, I would have laughed at you. I would not, because at that point I was saying, that's it, I'm fed up, I just don't want to do law anymore, that's it, I'm leaving, I'm not even going to touch it. And I still have friends from law school who would actually laugh at me now and say, ha ha ha, I can't believe that you've done a PhD in law and now you're teaching it to students. But for me, so it helped me come back to the law, and in fact, I would call myself, because I've come back to the law using socio-legal methods, and I've actually kind of gone back a full circle, because I've actually just rediscovered how important the law is after I've actually found that okay, it's all great, let's look at all these development theories and economic theories and how it applies to law. But then actually, between the time I did my master's and my PhD and during my PhD, I felt that there was still something lacking. I was getting very excited about these new theories, sociology, philosophy, so I was already into Foucault, economic theory, and looking at all that. And I thought, actually, what is my unique selling point, right? Ultimately, I'm a lawyer. And I struggled then, because then I started looking at things like the Bretton Woods institutions, the international financial institutions, sovereign debt restructuring, and I thought, right, actually, it's great, all these political scientists are talking about this, but they're not capturing the right thing, because I can see stuff that they can't see. I can see the problems with the law, but why are they not addressing it? And anyway, they've got this all wrong. Why are they talking about, something that is very clearly international law, but it's not international law, and, they can't distinguish between contracts and tort, and they can't distinguish between different forms. So, yeah.
Let me move on though, because I'm aware of the time, right?
Yeah.
I promised you to keep
So let me
us on
just
track,
finish,
but
yeah.
I wanted to ask you, and maybe with a brief answer, what are some of the limitations of the methodologies?
Yeah.
Right?
So this is so I'm getting to, so the limitations of the methodologies, I think, and which has brought me back to the law, is that we then pretend, the problem is, and there's a danger with it, is that then we think that we're economists, that we're philosophers, that we're sociologists, and then we lose sight that actually we're lawyers, we have a unique way of looking at the law, and the limitations of these methodologies that can always take you to and pull you aside, and you can become a full economist, or you can become a full sociologist. Whereas I'm not trained as a sociologist, I'm not trained as an economist, but I understand these theories and how I apply, and I can understand the law. And my unique selling point is to merge these two. So the danger, I would say, in terms of in answer to your question, Markus, is that we are if we approach it too much, we lose sight of that law, and that, like Lorenzo pointed out, the doctrinal analysis also has an important role to play, because like it or not, the law is there, and it governs so much of our part of our lives.
Right, and sometimes misrepresented as what the law is, right? I mean, all of us have read probably sort of non-legal analyses describing what the current legal state of affairs is, and we're also sitting there rolling our eyes. I've literally done this yesterday with someone whose name I will not mention, right? And I'm sitting there, I'm like, no, that's not actually how the legal system works. And
I'm sure everybody would, with Brexit, everybody would know. I think lawyers would definitely know.
James, let me pick on you again with the request to keep the answer somewhat brief, because we're aware of time.
three very quick.
Are we lab social scientists, and what are the limitations of the
So I agree with you. I just say that I agree with you on your analysis of the particularities of a lawyer. I'm working in an interdisciplinary group of political scientists, geographers, business school, and I'm a lawyer. And it's only when you interact with those people that you then start seeing the power of the law, the misrepresentation of the law, often the overblown claims that they think the law gives rise to actually aren't real. So often you're shrinking down their concept of what law can do because they have kind of overblown ideas of that. I can say a lot more detail about that, I won't. So activism and academia, as someone who again has been in both areas, I think the reason why I first came into academia and the reason why academia stands out from activism is because we go to try and find things out. We don't come up with a preconceived idea of what the answer is, we investigate. And that has to be the final line, I think. I work with a lot of activists and I give them the information that comes out of my research, but the crucial thing is my research finding is separate from their activism, and sometimes they don't like my research findings. So there's some findings that come out of this project. For instance, one of the findings in relation to trade and sustainable development chapters, which is uncomfortable for some trade unionists, is that we argue that trade unionists are sitting on these bodies because they are partly lack power within broader structures of society, and this is a way for them to get power within the structures of these international institutions. They are then ineffective there. So the question we raise for them is, would it be more effective to withdraw from these bodies rather than to sit there in a sort of quasi kind of powerless state? Now that's quite uncomfortable, the activism you're communicating information to. But I think that's an example of how I think, as an academic, your duty is to find out, and to put it fairly tritely, the truth, and to try and convey that. So that's your kind of, your duty, I think. Just one quick thing, because my research methods are qualitative primarily, right? So I think about, again, I've done lots of different qualitative methodologies, but the current one is a linked case study approach. So we have 3 case studies or 3 agreements. Within those, we've now undertaken more than 200 interviews. And so the scale of it's quite large. So I'm now getting comments back from reviewers. I've got 6 pages of comments from reviewers on an article who are questioning the case studies that we've chosen, so we're having to justify those. It's fascinating going in, different people have very different ideas of what looks like a justifiable case study selection, right? So it's worth kind of talking through with different people and thinking about what you're publishing before going through that process. And I think I'm happy to talk about that in more detail in the discussions. And in terms of kind of interviews, again, I don't think there is any set answer to the number of interviews one should overtake. I mean, you hear people having these discussions sometimes, I remember having them career-wise. It's all contextualized within the project you're undertaking, right? So you have to ask, what's your purpose, and therefore, who do I need to interview, and how many people do I need to interview to get an answer to those kind of questions. And that is the same, I think, for other kind of qualitative research methodologies. What I found in my project is that a number of the studies that I was looking at when I started, it literally they were based on 3, 1, and 9 interviews with Brussels-based actors to try and find out the impact of trade agreements in third countries. So you can see where the problems are, and then you're constructing something that looks appropriate to tackle those.
I think that this is actually really important, right? So at the moment I'm struggling with that myself when we're talking about regulatory chill. Which of the sort of case studies do you pick that make it amenable to the overall project, right? Not be told by the proponents of investment law that you're just trying to improve the field, by the opponents of investment law that you're just sort of a shill, on the other hand, in the middle of that. No pun intended, right? But Stefan is one of our best friends. Lorenzo, question to you, which is probably even more difficult for you, right? Where's the line between, but really I think for our purposes, maybe more important, what are the limitations of some of these methodologies? And do we just all put a big disclaimer in the front, and are we then exculpated from any further responsibility?
Yeah, I think the issue of the fine line is a very important issue, and it is an important issue for us. We do not consider ourselves as activists in any way. We don't do campaigning, we don't do advocacy in the sense of sort of public advocacy. But we aim to inform policy and aim to inform practice. So in the example I mentioned before, the political economy and legal employment piece, our role was to essentially produce a piece of research that sheds light on one issue that we think many people, including many activists at the grassroots, are actually grappling with. And our role is not so much to be activist, but rather to generate evidence and bring that evidence where it matters. And we think we need to do that because I think the days in which one thinks of informing policy by going off and doing research and then coming up with recommendations and going to the policy maker and saying, here it is, and they go off and implement it, I think nobody believes in that anymore, if anybody ever did. And so for us, it's really important that the evidence that we generate, the learning that we co-generate also with the partners we work with, is used not only in that mode of working with policymakers, but also to inform a debate in which different people, different stakeholders, citizen groups also have an opportunity to have their own voices, and they are able to do that based on analysis, based on information. I think that's very important, at least for the work I'm involved with, it's a very important part of our field of change. I don't think that makes us an activist, but it does create a link somehow between the research we do and the work that others are doing to try and influence policy. But I think it's a link that I'm personally feeling very happy to live with, insofar as we think that our evidence generation is based on research methods, samples, measures, as opposed to being driven by the advocacy. So that's one point. The second point is, yes, I'm always a little bit suspicious of sort of law in context pieces where there's only context, there's no law. I mean, actually seeing the law and the context, and so I always think it's very important for me at least to try and find what the legal angle and what the socio-legal angle is, and how that then makes perhaps for us some different analysis from what an economist say we do. And I also believe in multidisciplinary teams. I believe in working with others, and I think that there's a lot to be gained from that. And then finally, on the limitations, I think whatever methodology we opt for, there will always be some limitations. I don't think there's any methodology that doesn't have limitations, that doesn't rely on some assumptions, whether they're explicit or implicit. And so I think there's multiple things there. One is to make that, to acknowledge that. I think that's an important part of it, to make it very clear in the research what we know are the limitations, and also what we can actually infer, what we can conclude from what we've done, and what we cannot. It's perhaps a next step for another piece of research, or something to be followed up in the future. But also, ultimately recognize, make some sort of pragmatic assessment of which methodology is actually going to be fruitful in that case. So to go back to this report, there's been quite a few people who have been looking at this issue of whether international investment treaties promote foreign investment. And a lot of them have done it through macro level statistical analysis. You look at FDI flows, you look at investment treaties that have been signed, you look at this correlation, etc. We thought that there's a number of limitations with that approach, which we can go into as well, but range from data quality, definition of issues, complexities of investment flows in contemporary economic globalization, so you don't know where the country of investment is coming from. It's actually the real home country of investors, but often it's not, etc., etc. And so we opted for this other approach, of actually going to the companies and interviewing them. We were inspired by others, particularly Jason Yaki did that through a survey of US companies. We did it more qualitatively. But even our approach has a lot of limitations. We interviewed a small number of companies. There must be lots of, the universe of Chinese companies already in aggregate is huge. And we had a total of about 55 interviews, so you can imagine and they were primarily chosen because we sort of had connection to them, so they're not necessarily representing a sample. We have to acknowledge that as a limitation. There are cultural factors at play, so I mentioned before that there's very little awareness of investment treaties, but nobody actually told us. I knew nothing about investment treaties. We were culturally just what had happened.
But of course, some of them didn't know anything about investment.
But then you can figure it out exactly by how they responded to the other questions. Actually, they're saying they know it, but they're talking about something else. But actually, the main conclusion that we came up with in the report is actually we need that both China, the Chinese government on the one hand, perhaps can find out more about what the real concerns are for their companies, what the bottlenecks that they're facing. Perhaps we can tailor policy instruments accordingly, and African governments can also find out more about the treaties they've been signing and things like that. So it's finding out more because we recognize that actually what we've done is to shed some light, but with significant limitations. A step forward, but not the final word.
Okay. So last question, and then we'll open it up finally. This is a longer than we originally intended. Very quickly, and I really mean quickly, so I'm going to limit you to two. what are some of the biggest influences for each of you in your own work, right? So if there is none, that's great. That means time. If there is one or two, tell us who they are and why, what made that particular work or their body of work sort of attractive to you. James, you want to start?
Yeah, so I brought 2 books along. So I'll borrow the ones. I couldn't find the others, so I've only got 2. That's great. So this is a book called One Cooperation Fails, The International Law and Politics of Genetically Modified Foods by Mark Pollock and Gregory Schaefer. And it's something I read early on in my PhD studies, and it was a political scientist coming together with a lawyer to investigate together the issues around the GMO case. People might be familiar with the US case in the WTO, but all the politics around that in both the US and the EU that brought the case to being in the first place. Very different structures of agriculture, I meant to say, and agricultural interests, consumer interests in those 2 countries that brought this case to being. There's a fascinating study of looking beyond the sort of subtext, I suppose, of the law and the context, the historical context in which it came about. Andrew Lang's book, World Trade Law After Neoliberalism. So Andrew and I have been talking for years about our relative perspectives on human rights and trade, and he's much more sceptical about the impact of the human rights discourse within trade. And he made, by reading the book and by exploring that kind of skepticism, he made me think again about my own views on that, and kind of made me think about the kind of empirical inquiry that I wanted to undertake to investigate those in more detail.
Right.
Okay, so first of all, I've benefited hugely from interacting with the people I work with, both at IIED, but also the partner institutions who collaborate within the country. Interestingly, at IIED, there's very few lawyers, so that means interacting with a lot of lawyers, and that's been a really enriching experience for me. But also working with partners in countries been incredibly enriching for me, because when I first started, it was interesting in working in international development. There was this notion of knowledge transfer. We would be going out and bringing knowledge. And actually, I mean, I've been learning massive amounts from, they're not necessarily household names here in the UK, but in Mali, there's a jurist called Moussa Jiré. In Cameroon, there's a jurist called Samuel Gifo. I mean, these are people who really know, who really understand it, and they have a different way of doing things. That really has informed my own work, and I've brought that back, and I'm really proud of that. And that means, I guess, the tip is that the flows from that is that for me, being interested in socio-legal approaches is not just about reading text, but it's also talking to people, finding out what they're doing, understanding where they're coming from. I think that's really, really important. And then in terms of the more written word, if you will, early on I benefited hugely from the sort of legal anthropology type literature. There's lots of really insightful analysis in that space, and also more recently international political economy literature, very much trying to interrogate sort of investment treaty stuff, but more generally, really widely along in the non-legal literature, more theoretical literature. A few years ago, I was looking at somebody called Carl Polanyi, who wrote a book now 70 years ago, and I was looking at this is all about the law, even though Polanyi perhaps didn't make it quite so explicit, to some extent. So actually reading people who are coming from a completely different perspective, but really open up new questions, new horizons to interrogate the law, for me that's really important. So Polanyi one.
Just very briefly, I've got a long list, but I think two scholars which I've drawn a lot upon, being Braithwaite and Drahos. They wrote a very, very important book, Global Business Regulation, which basically looked at how different actors in the global system go about advocating for certain norms to be placed as regulatory norms, in the global system. And they're both lawyers. Drahos is very well known for his intellectual property scholarship. So so Braithwaite, Drahos, Global Business Regulation, and Sol Petiotto, who is a good friend of Warwick Law School, and who wrote and who's actually his book Regulating Global Capitalism has, is basically an amalgamation of his life's work. And Sol is actually one of the very first sort of law in contracts international economic lawyers, I would say, and also an activist because he was also involved in the tanking of the multi-platform investment agreement way back in the 90s.
All right. First of all, let me thank you. We would like to open it up to questions that you can ask here. The time is a little bit limited to 15 minutes. 15 minutes, but there are still opportunities after that to ask questions and exchange, as we said before. So, any questions from any of you? Don't be afraid.
Or comments.
Or comments.
I come from a background that is not law, so my first degree was actually a science degree. So when I came to study law, I think I already had an idea that law is about bigger. So when I hear people say, oh, doctrine, I have a problem with that because I come from a background which is, I come from a reverse background, where I come from a background where law has to sit in context. So, and I know the limitations of it. So I already had a view that the law will not solve everything. Now the problem I've had as a scholar is, when I try to think like that, I usually get criticism that you're not thinking like a lawyer. You're not thinking like a lawyer, you're too multidisciplinary. So my problem is, so what should law research be about? Because my thinking was that social legal research is about being multidisciplinary. But if you try to take that approach to some academics, that is not too loyal enough or too academic enough in the legal tradition. They want you to adopt certain doctrinal ways of analyzing things. So for example, the way I analyze an act of parliament may be different from someone who immediately has studied law, because my approach is different. So what would you advise me?
All right, let's collect maybe one or two more, if there are any. If you're too afraid, no, you're not.
I think my question leads on from yours slightly. Thank you so much for getting the discussion going in such a fantastic way and inspiring way. I suppose my question really is from someone who's looking at the kind of socio-legal issues. To what extent do you feel that the Western way of looking at law and economics, where they sell themselves as self-contained sciences, which have very little to do with people in the real world, that there's a broader kind of movement almost within scholarship at the moment of bringing the law and bringing economics back into the social sciences and recontextualizing it. Where do you see yourself in that?
Does that follow on?
Yeah. Thanks so much. My question is, thank you for that. Actually, I've done a lot of what you just presented. I'm not a lawyer. I'm actually in politics. And I realize that those who presented today, all of you are all lawyers. Am I right?
Yeah.
So, who is meant to use socio-legal methodology? Is it only for lawyers? And if it is not, then why are you here? Because I'm interested in the issue is this. I'm researching on ECOWAS, and if you want to research on ECOWAS, I also look at treaties, and then you draw from the treaties to interpret maybe how the state actors also relate with the other non-state actors. And so even the relationship between ECOWAS and other regional actors like European Union, they come together in agreement and they sign treaty or something that they actually find them. Well, I don't know. I'm also interested I'm also interested to know the kind of data you need. Is it because I've been using the treaty of ECOWAS in my own work? Maybe indirectly I'm also trying to use social methodology and also combine with the theories in the political science. So I don't know. Please, I would very glad.
So we'll keep it there for now. Can I ask for brief responses potentially, because I saw other hands already going up, and I would like to get as many involved as possible.
I think with Sandro's question, I'll leave that for James. Maybe we can take one or two questions. Claire's question, I think, on economic social issues and bringing economics back into the social sciences. I think that's, yeah, I mean, like I said at the beginning, that actually, you know, law in context doesn't mean a particular ideology, so they're also the Chicago School and the Law and Economics School, and they're very particular, you know, they're very economistic, they're very separated from the society. So although we're talking law in context, it's also quite a broad church, I think. We need to recognise that we're not singing from the same hymn sheet. And I completely agree with you. I think it's very particularised. I think that's a problem with economics in general. I think there are also a lot of heterodox economists coming out. I mean, of course, Stiglitz now has become very popular, and I'm kind of slightly, you know, wary about that. But we, you know, Carpoliani and, you know, other economists are very useful. So yes, I completely agree with that. Who's meant to use socio-legal methodology? I don't think we have a monopoly on that. We're quite happy to have a conversation later on in the workshop about how you can possibly, you know, tailor it. I don't think there is a particular view or a version of what it means. And you're right, you're completely right. We're actually coming from one perspective, which is, you know, we're lawyers and we're seeing how to incorporate it. And actually, we're here to learn from you guys, really, as well.
This was an event in disguise, really, right?
So I try and answer all three questions with one example, which is tricky. But, so my project at the moment I was talking about involves me engaging, so there's 5 of us on a team. There are 2 geographers, 1 political scientist, 1 guy from a business school, right? We're all looking at trade and sustainable development chapters in EU trade agreements. We're all, and you know, there's a particular focus around the labour standards provision, which I'll talk about in the last slide. So they're not lawyers, and they're looking at this legal thing. And they've got slightly different starting points, so they might be interested in the way that these legal obligations have been created, the political processes by which they've been created, and their effects in broader society. So the law just sits in a different place within their research methods than it does in mine, nuanced. But we're interested in the same sort of social phenomena, if you like. The crucial thing is and this comes back to the questions we have in the panel, what do our methodological expertises, what do our perspectives as legal scholars, political science scholars, etc., bring to the framing of that question? And what we found is that by talking to each other, the nice thing about that project more than anything else I've been involved in, every time we write research, we add our different lenses onto the problem in ways that were more disparate than I ever thought they would be. So I've learned more from that project and engaging with other disciplines than I ever thought I would, because there were assumptions I had about what their research was, which are completely groundless when it came to actually working with them. To your question, which is, so one of the things I think is that, one of the things that's also amazed me is the new literatures that I've started reading as a legal scholar as a result of engaging with them. So I just think legal scholarship looks quite sealed off from the rest of the social sciences, right? And so they will know, all of them from different disciplines will know stuff. They'll all have read certain things I haven't read. And so for me it's been a process of engaging with what the rest of the social sciences has read as part of their kind of Bible of what they need to have read. Maybe it's just me being ignorant. I have just an ignorant lawyer, but I think it's also the fact that I'm a lawyer, not just an ignorant lawyer. And the kind of the stuff that we read as our kind of learning, growing up tools of learning about legal scholarship looks quite distinct from what other social sciences learn, and that creates barriers. And so if we want to kind of eradicate some of those barriers, we have to engage better and more deeply with literatures that actually, when we read them, look like they're discussing very similar problems to the ones that we're interested in. So then, Cindy, finally, so what does this tell us about what we should be doing as kind of legal scholars? I think that is just, there is no answer to that question. There is no one truth about what legal scholarship is. There is a constant set of people pulling it in different directions. to try and engage with different kind of questions that we think are important. And the question we keep on having to ask ourselves is whether our expertise, our methodological approaches create kind of meaningful knowledge in relation to those questions. I don't think there's anyone who says that there is a truth about the limits of what that inquiry should be. I think that's just constantly up for discussion and debate, and the best way of defining that is to just keep discussing between different branches of the discipline who have different answers to those kind of questions.
Do you have anything to add? I said that there were points were engaged with. I'm wondering whether there are other questions. Right. Let me just say something as well. Right. So bringing economics back, I just recently wrote a blog post entry on a talk where I actually said to the economists that they should probably actually engage with others. Right. I think every discipline is sort of almost predestined to stay cloistered. Right. And I actually think that lawyers. I have a slightly different perspective from James. I think lawyers are actually pretty decent at looking at other places, or at least have the capacity to do that more so than others, right? So when I read that World Bank IMF WTO report and commented on it, the methodology was clearly full of economists, right? The entire bibliography at the end was nothing but economists. There was one lawyer or legal academic I could identify, and his only contribution that they cited was one of political economy, right? And so I was like, this is kind of...
Why don't I put economists below lawyers in terms of
I'm not saying above or below, right? But I think lawyers actually... I think one of the ways we could
some lawyers.
One of the ways you can do this is not to be necessarily seen as destructive lawyers, because I think that's oftentimes the perception lawyers have, or that exists, right? But as constructive contributions to things that are going on the outside, right? I think Celine put it really, really well. Law, sort of socio-legal work, right? If you look at the Law and Society meeting in the U.S. every year, I don't know what to make of that anymore, because its tent has become so broad that it's really difficult to draw any kind of lines anymore. And I worked for someone when I was clerking on a court at one point, and his basic take was, I use the methodology that's useful for me at the moment in time to get at the answer that I'm seeking, right? And he would use different methodologies depending on the circumstances. I think that's exactly what it is. That, of course, requires that you know something about these methodologies, right? And what the benefits and limitations of each is. Now we've talked for too long. I know you actually know. Yes.
One of the questions that you asked the panelists earlier on was about what are the limitations of this methodology. And it's interesting to hear your responses, because for a lawyer, well, someone with legal training and being immersed in a world where everything is quite interrelated, because I work on the area of subnational government in international economic law. And it's an area that is fiercely contested, because traditionally they do not have a role. So I recently went to a law and economics conference by the Society of International Economic Law, and I was challenged very strongly by a lawyer about my views in relation to the role played by subnational government in this Canada-EU-CETA agreement. And basically, it got to the point that his argument, or his annoyance, because he was really legal, but he is an EU lawyer, and he was like, why are you trying to bring in something that has no basis here? And it left me thinking, okay, it means I need to justify, in a way, what I'm saying, what I think I'm saying, which is actually something that it's evolving and it's happening in reality, even though the constitutional and legal context do not capture it yet. So that's why I came for this workshop, because I'm thinking about methodology. What methodology can I rely on that would help me to be able to put forward an argument that would not be literally shredded, because it's something that may not be held by a majority of those out there. And when I came out, someone told me, and the person said to me, why not tone down your viewpoint. Disguise it in a way, but don't say this. And I'm like, someone mentioned about truth, that we look for truth. Right. So what do you do when you're trying to bring out the truth and you are being faced by challenges from lawyers on one hand, like you mentioned, they're not being legalistic about it, but at the same time you are then trying to find the right methodology and a maze of methodologies in social science and economics to be able to say what you're seeing that is actually occurring.
So maybe we give some general answers, some particular answers to those kind of questions, I think is what comes out in the workshop. So to your specific project and the methodological challenges faced there, I think we'll leave that for the second part of the discussion. But right, anyway.
I have lots to say about it.
There you go.
Because I had the same discussions at one point with people, and I think it's really difficult to convince people who have blinders on and other things are going on. Jenny, and then I have you. And if you can signal to me that you want to see, then that helps me.
Cool. I just had a couple of comments really. It was so helpful, and I think it's something I struggled with a lot because I came from development studies, which is multidisciplinary in the idea, in the sense that it was human geography based, but it was a lot of political science and economics, and I moved into law, in my master's, and I think one of the things that I find interesting about socio-legal approaches is this idea of trying to think socially about law, and I think this is one of the benefits of the economic sociology of law movement, is trying to think in a pre-disciplinary way, in the sense of how do we get economics and law, and I think for me that was very freeing to be able to think actually my perspective about kind of trying to step back and even though I have some legal knowledge and I have some, just trying to think about at a more basic level, what is happening socially in this context? And what are the languages and the concepts that we use to create, that are commonly used to kind of create a picture of what's happening? So, and then to kind of deconstruct that. So maybe that's, I don't know if that's acceptable from a legal doctrinal perspective, but I think the legal doctrinal perspective tends to reproduce itself by saying, well, we don't accept these kind of perspectives and you need to meet this certain criteria in order to participate in this legal conversation. And then so what happens to the deconstructivists, and I think there's a sense in which the academic activist binary that Markus flagged up is actually a kind of fake, in the sense that, of course, there's a sense in which we're seeking the truth and we're not being activists in the sense of having our own agenda or having a predetermined outcome. But I think this, again, there's a sense of the negative aspects of activism. It's like politics is always delegitimized. And I think, I guess my question would be, is that a real binary? If we're committed to open-ended discovery, intellectual discovery, is the academic activist binary that useful? Because isn't there a sense in which doctrinal thinking is also contributing to a certain view of the world, and that's very activist in a sense because it has very strong links with dominant hegemonic policies. Just to kind of, I wasn't quite satisfied with that.
I think my question was quite a lot of the first part of your question. I'm saying you started with that one reason why you went in for social legal was because you saw that the legal categories of hard and soft, of maybe national and international, they don't go really well with what you've been seeing or what you've been observing. But then during the panel, I had the feeling that you all had somehow your own working definition of the law with capital L. I'm not really, so it was much more about implementing the law and practical effects in society of the law with capital L, but not really questioning of what you actually perceive of what is the law and where your impression of what is the law with capital L comes from and how this resonates with what you're looking at. And so my really brief question is do you have, all of you, a working definition of what is the law for you, and is it just this procedural definition of where it comes from or where in which format was developed, the document, or the norms you're looking at?
Well, just very quickly, Laura, just on that, my working I don't have a working definition of law. I take a very deconstructive view of that. And for me, the law is for me, there's a classification of how, the law are any sort of norms that govern behaviour of a particular area that we look at. So it's a very socio-legal kind of like conception of law. But I think because of our discipline, there is a need to somehow categorize it in a way that also there are fixed, there are certain legal norms that have greater weight, for better or worse, and then, you can deconstruct what that means. I think that for me, we have to draw the distinction somewhere, not because we want to, but for the purposes of categorizing things in general in the world today. We do that. I think I would just want to go into Jane's point about activism. Yeah, I completely agree with you. I think it's a very fine line. I am an academic activist, and I don't apologise for it. I try to do independent inquiry, but I know that I am biased in some way in terms of my view of what I think the world and how society should function and should be. And so, for me, first and foremost, I have a vision of what I think, the society and economy should be, and I try and investigate there is a problem. But I don't apologise for taking an activist stand, because for me, I also think academia is my way of making a difference in how, because I teach in a particular way and I research in a particular way, and I don't apologise for that. So I do think there is a fine line. I think we need to maintain academic rigour. In terms of making our work, as you were saying, how do we justify it in the face of those people who then being robust about it, pick a methodology, but be robust about it, and be scrupulous about your data collection, be scrupulous about what you make, and be rigorous about it, and that's the way that you justify it to these people. And I think there's also an intersectionality thing as well, in terms of the power dominance in the spaces that we engage in, which we also have to question as lawyers. And as lawyers from the South, for me, as a woman, and a woman of colour from the South, that means also the issue of intersectionality when I go into conferences that are predominantly Western, Eurocentric, male, and white. So that's a different discussion, but that's something that we need to think about in terms of how we articulate ourselves as well.
So, activism and research. So, I could probably retract a little bit of what I said earlier, which is say, and I didn't manage, I think that what I said came over as being pejorative, and it wasn't meant to be, in the sense that, so when I did the police complaints research, Liberty had been campaigning for independent investigation of police complaints for 100 years. Whoa, that's activism with a kind of purpose and a sense of mission, right? They've got this idea that this thing should happen. And they've got a stated position behind that that is consistent and true, and they're fighting for this thing, right? And that seems to be really important, and we need people who have that sense of purpose around the set of things that they're campaigning for. As a researcher coming in, I was then trying to investigate how that would work, right? And I found that exciting and interesting because I was for independent investigation of police complaints, and then I was able to investigate this thing in detail. What I found then difficult was I wanted to carry on doing research on Liberty, but then they had a number of other positions about other issues, right? And I thought, I don't know what I think about that. I don't want to think about the liberalisation of drugs yet. I want to come and empirically investigate what the effect of that might be. And so then the kind of idea that as activists they had lines about particular things that they wanted, and I had things I wanted to investigate came up against each other. Now, the reason why, I think there are people who are more research orientated who work within civil society organisations, so they're kind of researchers within activist communities, and maybe academics who are more activisty who are cited within research institutions. So the crossover between those two types is a lot more fluid than I was thinking about my own experience, which was I felt more comfortable moving into an academic environment because I wanted to move somewhere where I could be exploratory rather than that's what I'll say about that. In terms of concepts of the law, so my concept of the law is incredibly fuzzy, and the reason for that is just I think any definition of what the law is needs to have a number of different dynamics to it, about the kind of laws, coercive power, the laws, a kind of normative coherence. There are a load of different characteristics that I think make things legal and non-legal, and there's a load of fuzzy boundary all around the edges of it. And my way of escaping that problem largely is to concentrate on investigating things that look like they're within the kind of, there are things that people would say are inescapably kind of legal. So I tend not to be investigating things around the fuzzy edges. But I don't have an answer to the question that doesn't go into, wouldn't be complex of looking at different kind of paradigms of what we think are legal and non-legal. What have I left out? Someone else, another question? No?
No, I think it was it, actually. Okay.
Yeah, I have a couple of thoughts. So first on the subnational governance and international economic law, we're interested to see how one could deny the relevance of subnational governance in the context of the whole CETA hostage of the pilot in Bologna. So a subnational entity, essentially, because that was back in October. Or where you have a number of investor-state disputes. Disputes where essentially the issue is very much the relation between the local government and the federal government. So there are a number of cases in Mexico and elsewhere where essentially the federal government approves something and the local government doesn't, and then it goes. So it'd be interesting to see. I mean, I'm looking forward to the session to hear more about your project and how what you're actually looking at. But I think it's fair to say that there are certainly a lot of people out there that do not believe in the value of this type of work. And it's certainly the case with there's people who do this type of work. The research rather for in this space does risk sometimes falling into stools because it's not realistic, and so it doesn't have the law, but it's not economics, it's not so way. But I suppose to put a positive, an optimistic spin on this, I have the impression that actually things are changing a bit. And while that has been the case for a long time, I think there is a growing number, in fact, also a new generation of scholars that these issues have got much more in their mind to socio-legal approaches. And in fact, even just squarely in the international investment law space, there are lots of people doing empirical work on the arbitration proceeding, the arbitration process, whether they're biased there or not, the regulatory chill, lots of empirical research being done there, FDI, lots of empirical research. So I think actually we're seeing, and people from different disciplines are talking more and more. So you've got James' experience, but I can also from other people who are working with people from international political economy. So I think slowly, and I see a tremendous, as personally, we were talking about this last night, I personally see tremendous value in this type of events where people have got similar interests, maybe they're feeling slightly isolated in their respective contexts, are coming together and sharing ideas, sharing tips and building that sort of community of practice that over time can perhaps tip the balance of, compared to where things stand now. I also had a couple of thoughts on the issue of the academic activists, and I guess it partly depends on what the definition of activists. In a sense, we're all activists because we all have a worldview, and that inevitably informs who we are and the research we do. I suppose when I look at the sort of work that we do within IIED, we wouldn't consider ourselves as activists in the way in which the term is quite often commonly interpreted, because people have in mind the big brand NGOs, the campaigning, you go in the tube and you find these posters, the dying child, we're not into that, and we need to make it very, very clear that we're not. And one way we frame it is that we are we are value driven, so our mission is to promote sustainable development. We have a clear agenda here, it's explicit on our website, but we are evidence based. So the way in which we work towards that, it doesn't start from a preconceived notion, but it really does try to find out what the issues are and how best to address them. And then finally, on the issue of what is the law, I think it's huge. I think you're right. It really shouldn't be taken for granted what is the law, and in the area that I work in, it's huge because historically, this is, if you go back in history, and history always does matter. This is the issue that allowed some countries, particularly from Europe, to go out in Africa and say, oh, here there's no states, there's no law, nobody owns this land, it's all up for grabs, essentially. Whereas if you would talk to people, they have a very clear idea about the custom systems they have and the way in which they hold the resources and they manage them, who has what rights and what sources, but somehow it doesn't count as law. So there is, and then in some countries now it does because the legal framework recognizes customary rights, but the way it's done is effectively creating some distortions in the way in which those customary systems pan out on the ground. So I think we should always ask those questions and sort of keep that interrogating role on the fundamental issues. I suppose it partly then depends on the specific research project you're involved with. So if I'm working on sort of local sort of land issues in Africa, which I've done some work on, then that issue will be paramount. If I'm working on bilateral investment treaties, China, Africa, and where they work, I need to take a lot of things for granted because otherwise this would be not like a book. So in a sense, it partly depends also on the specific focus we're trying to do with the research, and so which assumptions you can sort of take for granted and what you actually need to unpack. But I mentioned legal anthropology in the sort of influences, and certainly that's a key. That what counts as law, who defines what counts as law, and how does that play out is a really important issue in that literature.
So one quick answer to your question was, I still sit in rooms now where I'm the only person who takes the legal issues that I'm thinking about seriously, and I'm surrounded by other lawyers who kind of look at me like, what is it? So I don't think you should feel that's an unusual occurrence. I think the question is how you make those conversations work better and how you give credibility to different kinds of legal work.
Yeah, but let me pick up on that, right? So this notion of sub-state actors, I think if you talk to sort of hard-nosed lawyers who have not read the Articles of Stake or are clinging to the Articles of Stake Responsibility in international law, right? May not have read Articles 27 and 46, I think, and so forth. But I think it's sort of abundantly clear, and I don't think actually that the example from Wallonia is the answer to that, because that's a constitutional question within Belgium of what's going on, right? But there are actors within international law which very much have, and not only influence, right, but have rights and responsibilities under international law, right? And that to me is a separate, conceptually different question, right? And I think that's really hard to square. And coming from a European lawyer, that surprises me even more, right? Because the European system is one of multi-level governance, per se, right? If anything. I forget who mentioned it, right? Truth, right?
I think it was me, I should know. So.
Yeah.
It's going overblown on complex.
The question of truth, right? So when I did my master's degree, I was surrounded by law and economists, right? Law and economics people. And they were all sort of saying, we know what the truth is, right? And ever since my conception of the truth is roughly the following. Imagine truth is sort of some kind of mythical ball sort of floating halfway in this room. And we all look at it from a particular angle, but none of us will actually ever see the whole thing. And this limitation, right, knowing that that's your limit, that whatever angle you're looking at is only one of them, one of many, right, is, I think, to me, sort of the heart of academia, which leads me, actually, funnily enough, to Jenny's point, that I think academia and the line between academia and activism, I want to hold on to that for one simple reason, because it's very, very, this is fairly dear to me, right? And I think there's sort of some important sort of public policy implications like that. If academics are seen to be activists only, and that, whether true or not, but as a perception, is really hard to come back from, right? You see this in the post-truth world. I think it's really hard to then make credible claims and stay on reasonably safe grounds. I can give you an example of, you may know this, most people don't, I would consider myself a bicycle advocacy person, right? I do this fairly harshly, but I separate one, namely the bicycle advocacy, from research that I do on what the basis of my arguments are. Those are two separate issues. And I think it's useful to separate them somewhat in one's mind. The problem is, I think, here I completely agree with you, is that the black letter lawyers almost never have to justify the basis upon which they make their arguments. That is, I think, the distinction, right? But I think that is something that one could question, right? So, and I think one should, right? So on the question of regulatory chill, that's exactly what we're trying to do. wait a second, when you say regulatory chill doesn't exist, that may or may not be true, right? But at least I want to question your underlying rationales for doing this, right? And with respect to regulatory chill, it's really difficult because empirically it's really hard to prove, right? I mean, the cases that never happen is sort of our working finding. Because those cases don't happen. If I go into any kind of database, I will not find in the pleadings before an international tribunal the term regulatory chill. Maybe once or twice, but they happen much more frequently then, right? Than databases would ever come up. So then you go to interviews, and then I run into the same issue that Lorenzo faced, right? What country will actually give you access to the documents that would show that, right? So we've been trying to get in touch with Uruguay. We got some ways into Uruguay, the Uruguayan bureaucracy, and then all of a sudden we don't hear anything back once the documents are supposed to be given to us, right? Because we'd love to see the reams and reams of paper that Philip Morris's lawyers had actually sent to Uruguay, because I'm sure there was a threat beforehand. We will put you in front of an international investment tribunal. Someone must have given that line, right? And so getting to that point is really, really difficult, right? So that's, to me, is another sort of almost inherent limitation. But let me leave it.
I think these are kind of issues we should talk about. So those technical questions as well, I think people would have insights about that in the second part of that session.
But I think we're sort of run out of time. I haven't seen any other hand going up. If I missed someone, let us do one last round. Yeah, one last round. You and one more person talks, and then we'll have to wrap it up.
My question is more, I think Celine had made a comment earlier about the limitations of doing socio-legal work, where we're lawyers, but sometimes we think that maybe we're full economists or we're full geographers or whatnot. And one of the things that I've noticed is that, I guess because I'm doing illegal ethnography, where do we draw how do we stay true to the law even though we're using social legal methodologies? Because sometimes I read work and I think, well, this is written by a lawyer, but it looks like something completely different. So how do we define what's social legal as opposed to in a different discipline? Or how do we write in a way that feels like we're...
So we park that question for the workshop.
Okay.
I think that's a methodology question that we can certainly address. Sorry, your name again?
Alison.
Alison, you're in my workshop anyway, so let's talk about that.
Can you also quickly say who you are, where you're from, and then...
Yeah, I'm Rafael from LLC. My question is drawing from your answer actually, but it's up a little bit from what it's so I'm from Brazil, and back home we have always admired European and American academia, because there's this idea that here or there in the US, scholars are unbiased, and they can focus on research, and they don't have to struggle for resources and this kind of things. Well, let's say that my last years in Europe and the US showed me something different. So for me, so since we are not talking about more specifically about methodology here at this moment, I think most of the question is about the struggle in academia to decide what it should be inside or outside of the boundaries. So one most doctrinal-oriented scholars say that you're doing is not law, or is it law, or is it kind of different law, or whatever. The problem is, in general, they are trying to push you away, and to say, at least from my impression, that if you're doing is not law, you should go somewhere else, because here we're doing law, and law means doctrinal analysis, blah 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 blah. The problem is, my first question is how to handle this, because on one hand you might not want to burn bridges. I mean, you might also like, this is my case, I also like doctrinal analysis, but doesn't mean that I want to just do doctrinal analysis. On the other hand, is how to use, and that's the part that frustrates me, is it's clear that this is a very ideological move. I mean, when you say you're not doing law, you should go to, social theory department or ID department, means that, what you're doing is not finding the truth from a legal point of view, and then we should not, consider your scholarship as valuable. And I'm just referring to him because I think we have just participated in CL's conference, and we kind of had very harsh opinions about our pieces right there. So I would like to listen to you to see how to handle the situation that sometimes first you are in an environment that there is a lot of conflict, and how to handle this kind of ideological backlash, and at least from my point of view, against more interdisciplinary. I wouldn't even call this social legal, but just interdisciplinary.
I just wondered, James.
Sorry. Give me a second.
It
seems like there's a two-finger, as one would say in the US, right? I'm really onto this, but it has to be 30 seconds no more.
No, but I was just wondering, since we do have quite a number of questions from, that people wanted to address from us, I don't know whether we wanted to change the format slightly and just take a short break now, 5 minutes, and then come back, because they're quite important questions, I think, about how we address these issues, and then Markus might have something to come in, and I think it might be useful for us, if you feel that it's useful for us to have a conversation as a group, and then we can...
Let's be democratic.
Yeah.
So who would like to carry on with the group discussion for go and get coffee and carry on for 10 minutes? Who is keen to move into workshops? So just worried that there's another thing that was promised and we don't know how much. You might enjoy this conversation, but actually think the conversation is coming to me so much better that I don't want to carry on with, because we have about an hour and 10 minutes before we finish. So we can go over slightly. Are people rushing off at the end? So we can go over slightly to sort of 1:45 for the formal proceedings. Does that work for people? Okay. So shall we have the final couple of questions? Go off and get a cup of coffee to refresh yourselves, and then we'll come back and answer those before moving then into the workshop. Is that okay with everyone? Without having to do it.
So yours was a two-finger following up.
I'm sorry.
No, I like this.
Yes. Earlier on I mentioned that my research interests lie at the intersection of transnational law and global governance. I should probably have been more specific.
I was actually wondering about that.
Yes, because that's right. My PhD, which I completed a couple of years ago, was on the natural resource governance, so basically oil governance in Angola. So extractive industries, similar to what Celine was doing. Before then, I studied law. I did an LLM, and then I studied the crisis in Darfur and the responsibility to protect. I actually ran away from that because I felt so depressed about how the world responded to the crisis. But it's not just how the world responded to the crisis, it's how the world responded to the crisis in Africa. And it brings me back to, I've had similar experiences as others, in the sense that when I'm at international conferences, my point of view is dismissed, in a sense. And I wonder whether it's in the extractive governance debate or in the law debate. And I wonder whether the question is not so much what counts as law, but what counts as knowledge. Who defines knowledge? Who has the right to know? I think that's the more general question. As a researcher from the global south, why am I dismissed when I have a different point of view from somebody who's done research from a Eurocentric, Western centric point of view? So I think that's the broader.
Very important questions, I think. We don't have to.
So we grab a cup of coffee, come back in, we'll answer the questions. Let's go. Grab a cup of coffee here.
So this is the Warwick fashion. We now Dave is in charge. So we had a couple of more questions as you recall at the end. Are there any more questions that have come up in the meantime? Otherwise, I think we would sort of address some of the issues of interdisciplinary work and so forth. I have plenty to say on this, but I'll hold back initially. Do we have another question here?
The very short question is, I think it's very important discussion, but I wonder, it's maybe not related to methodology, but relates to the future profession of lawyers. So I wonder how, as a also lecturer and professor, how you interpret social legal notion in your teaching.
Okay.
Anyone else? Yes.
It's brief. So my question relates to theory. So I had the feeling listening to you, you'll have really applied and practical and empirical studies, and if you engage with bigger theoretical project, or if it's something you briefly said.
Not doing anything more, then we should round up.
Do you want to start? Yeah, I mean, I just wanted to just say to all the people that Raphael, I think you raised the question of being, that fish out of water in those kind of situations where, you're in a doctrinal situation and you're always trying to justify that, point of view, and Lillian meant it as well, and a point of view raised it as well, that she's always dismissed, and what's the point of law, and what counts as law, what counts as knowledge. And I just wanted to, that's part of, my personal perspective as somebody who has worked in the South, who works on issues relating to developing countries, who go out and challenges the Eurocentrism of the law, of international law, that it's difficult, but we need to have those plurality of voices, otherwise the discipline, we need to challenge what is knowledge, and we need to challenge what is law, we need to challenge the basis of international economic law, and who has made it, who is it for, and in unmasking this power relations, we also need to open up the spaces by which we, have to speak up. So I just want to say that it's very challenging. I've been there, I empathise. But being robust in your methodology, being firm in your arguments, and being very resolute in that your point of view is also valid, that we might do things differently, and we might see things differently, but actually, we're pushing the boundaries of the scholarship, we're pushing the boundaries of the law, and we're pushing to change. And this is what I want to get to, because this is what thing that comes up to me, it comes back to me over and over again when I hear things from junior scholars, people just starting out, trying out these different approaches, and also Southern voices, that we always feel a little bit marginalised. When we're in those situations, we always feel, oh, you're looking at me, is it because my English is not that good, or, I'm not saying the right things, not saying the right thing, I didn't go to a League Law School, but no, your point of view is valid, and our knowledge is valid, and how we construct things from our worldview is valid. And I just wanted to say that and reassure you that it's challenging, but it can be done, and we have to do it, and you guys are the future.
So, building on that, I've been in room, so there's one area in Marina, this very well, human rights and business, where there's probably hundreds of scholars working across on the world, and I think I value the work of about 3 of them. Seriously. So I feel there's some areas of the world where I work where I think there are lots of people doing really valuable work, and there's just a plethora of different approaches, and then in that area I think there's people are asking the wrong questions. And there are about 3 or 4 of us who all think this, and we go along to things like the UN Forum on Business and Human Rights, and then again this last time, and then we kind of write challenging things afterwards, and everyone ignores us. And my thought about that is in 10 years' time, I think we'll probably be right, and people will go, why didn't we ask these questions earlier? Why were we so, again, dominated by the internal coherence of law, dominated by characterising different forms of, rather than looking at the impact of what the human rights agenda was doing in the business world? I can go on. So I won't go into that. Handle this box and stuff, but building what Celine says, I think you've got to have a confidence in your convictions to think that if you think something's important, and there was a way of researching it, there are important questions, and that you have a methodology for exploring them, that is vital knowledge. But, and here comes the big but, there is a danger in being isolated on these kind of issues. There is a danger in not challenging yourself about your own research methodologies and the limitations of what you are doing, right? So there's kind of a nice place to be in a way, the only person who really knows what's going on in the world, what everyone else is deluded. It's kind of, it's really quite fun, isn't it? Because it's like you can sit there kind of passing judgment on people. So the crucial thing is to find your networks of people who can enable you to challenge your own work and its limitations. And a lot of the time, so I've gone to events like this and found people within academia, and then I've looked outside academia to other people. So for me in the human rights business world, there's a lot of people working in the UN and in NGOs and other places that I will send my work to on a regular basis and say, read this. Does this make sense? Is this right? Do you think? And get that kind of critical engagement. So I think you've got to find a way of critically reflecting on your own work and making sure that you have those networks that help you do that. So what counts as knowledge and what counts as law is just contested. So it's a battleground about where the discipline sits and what direction it goes in. I don't think there's an answer to that. I just think there are, for me, things that look more robustly like research, which look more or less centered around the question of law and taking law seriously, rather than law being the starting point for an investigation that looks economic, a whole lot of other issues. And so part of the debate we have is what our discipline should look like and what trajectories it should take to, for me, answer important social questions. And that's the question I think is often missing from the debate, which is what is important? What is it as scholars that we think are important questions that we should be looking at that have legal dimensions? And the idea that some, that exists as a question to which there is a definite answer rather than just a struggle, depending on people's ideologies, backgrounds, thoughts about the nature of the discipline, I think, is probably to kind of think that there will be an answer that will come to everyone that won't happen. It will be a struggle in which different groupings of different scholars will have their say. Hence, I think the importance of people who have particular perspectives getting together and thinking about not just their own individual research, but a body of research which explores questions, because that's what research is about. It's, we tend to think about our own lone scholarship, but actually, if our scholarship is going to have an effect, it's going to be within a bigger field in which more people are asking the same kind of questions that you're asking.
Yes, I don't think I've got anything to add to what Celine and James so beautifully said. I think that captured it very nicely. I think just a reminder of the question on teaching, which I can't answer, but also on teaching. And just one sort of further note to one of the many points that James and Celine have made, particularly in relation to looking also outside academia, and I'm based outside of academia, although in research. And I think that people outside academia are looking for grappling issues that are not necessarily just legal and issues or issues that require only legal analysis, and therefore I think there's plenty of bridges to be built where people are working more in practice, in the sphere of practice, and I would certainly encourage you to look at networks not only in the academic sphere but also beyond that, and I think that can be quite rewarding as well to have a sort of conversation going between the research and practice.
So I've got two questions, actually.
One is teaching
and then theory as well. Sorry, it's really fun.
Yeah. Do you want to do one or I'll do one?
Yeah, I'll a quick answer to the teaching one, which is the great thing about being an academic I have found is that the external scrutiny of your teaching is very limited, right?
Don't say that, that's a test coming through.
So there's a sense in which it's the exact opposite. My brother-in-law is a secondary school teacher, and everything he does is scrutinised in terms of a very rigid curriculum. Whereas I've got a lot of space and time to be able to create the course that I want to create, to talk to my students about the things that I think are important, and to an extent, as long as I can create a coherent course which gives them a set of knowledges that I can then provide some kind of test of in the end, knowledge, understandings, principles, ideas, and they see that process as valid and legitimate, then there's a lot of space there to be incredibly creative. And I teach everything from a human rights in practice course, which is about very often getting people to do community projects, to kind of international economic law courses in which I'm teaching a wider range of international economic law subject matter with a very kind of social context perspective. And so I think that's really exciting and empowering, actually. So I'm an instrumental user of theory. So So I use theoretical insights to thicken out my understanding of problems. So Markus stopped me in the middle of me reciting off all the theory that informed the question. So feminist theory, third
now
world
theories, chance to do it.
Theories around supply chains governance that, and a whole load of literature I've been exposed to who were dealing with different scientists. But for me, I'm like a magpie taking that in order to drag it back to my problem to inform and thicken out my description of it and the aspects of it that I need to investigate, the people that I need to interview, the areas I need to explore. So I'm not a deep and meaningful man who explores theoretical problems for the sake of being a kind of someone who has something to say meaningful in theoretical debates, rather to take that theory to try and illuminate the understanding of the practical problems that I want to investigate.
I think that's basically it. I think for me as well, in terms of the use of theory, I'm fairly instrumentalist, I would say as well, in the sense that I use theory to understand the phenomena of law and how law functions in society. I might have specific people that I'm particularly drawn to because they resonate with me, and you'll find your space, I think, in that sense. When you find a theory that works, it almost is like, and that carries on throughout your whole academic life. I mean, some people have a very fixed, rigid theoretical approach, Marx, Foucault, whatever, and then they take that all throughout their sort of careers, and they become experts in it and everything. But the danger of that is that then you shoehorn your empirical data to fit that theory, and it doesn't always work. That is one of the limitations of being this, a social legal scholar. We have to be very attuned to that. Is that theory, I think, we have to be cognizant that theory serves a purpose for me, because I'm not a philosopher, I'm not a theorist. Unless you're a jurisprudential person and you want to use law, international economic law events and rules and things to illustrate theory, which is different, which is slightly different to what we're talking about here, which is more or less using theory to illuminate or understand the legal phenomena. Other people might use legal phenomena to illustrate theory, which is like, it is a separate thing, but it's a more jurisprudential debate.
So, I think on teaching, to come back to your question, right, is pretty much what Jane said, right? I think that there's a great deal of liberty, but I do think that when you teach law, and I think that depends on the institution that allows you to do this, right? So I think that goes back to your question as well. I think there's certain institutions that allow you to bring in, allowing is a strange word, right? But that are more permissive in letting you bring in other areas, right? Or other approaches. And I think at Warwick that's pretty easy, right? And I think your students select themselves, I think, a little bit also along those lines, certainly on the postgraduate side, more so than the undergraduate side. But when I teach international economic law to postgrads, right, I certainly teach like letter law because I do not think you cannot do that. Right? I do not think, and people may disagree in this room, but I do not think you cannot do that. But on top of that, you can then, and someone sits next to you on your right, who's been through that look at him, right? Who's been through that course with me. But then on top of that, you then start to ask questions, right? Because you need to have certain grounding and firm understanding of what the rules are before critiquing them. So that's one. Coming back to your question on interdisciplinarity. Number one, institutions. I think certain institutions are more open than others. Number two, I think one of the questions, and we talked about this outside, right, is how do you get people who otherwise would not be interested in your work, interested and not shunning it off as sort of the cuckoo people, the people who are on the fringes, and so forth. And my approach may differ from other people in the room, right? I think if you are not in the center of the debate, then you need to make people in the center of the debate become interested more in your work. And that means somehow attaching to that discourse. Somehow, right? Whether that means showing that you have a very firm grounding in the legal, sort of the black letter law, and then being taken seriously as a lawyer, and then adding on top of things, right? Which is what I've tried to do in one of my pieces on where I looked at how we translate uncertainty in science into sort of legal decision-making issues, right? So I ran down at that point the SPS agreement in very fine detail, right? And said, this is what the SPS agreement does. And then now the question is, how do you translate uncertainty, which is inherent in scientific inquiries, into legal decisional categories, and what translation mechanisms do we have, right? And that got people interested in sort of, wait, we didn't realize that was going on, right? And so then you run through I ran through a whole litany of people and schools of thought on how to translate this, right? And pure empiricists all the way to pure contextualists, right? And I anchored myself somewhere in the middle, right? On the precautionary approach that I think the appellate body is taking. But then I do think that showed people that wants to be taken serious. So I think there's a way to combine those two things to show that, right? And I think that then sends a signal. And I think specifically to early career researchers, I think that's not unimportant, because there's one concern that I think that I have is otherwise you are sort of putting yourself potentially, or being put, right, into a silo, and then people just talk to one another within their own little sort of areas of interest, and that's not useful. Because part of, I think, the reason why we do what we do is we want to get other people interested in our thoughts. And that comes only when your own work is recognized as at least somehow important, somehow influencing someone's thinking, right? And I think you can have long debates about who needs to move towards whom, right? But I think making people recognize that there's an added benefit to what you're doing is an important thing, and crafting one's own work in that and showing that it's important, that it's useful, I think is one of the things that one can do. You don't have to do it, but I think it ultimately helps you in the long run to get your work recognized. So I think having now had the last word, I think we'll wrap it up here.
Yep.
I will bid goodbye. If I can be of any help in the future, then please don't be afraid to reach out. And I'll hand the floor back to James, who I think has plans for you.
So
thank you very much, Markus.
Thank you, Markus, so much for sharing and sharing. So our plan is this. A lot of you wrote back with answers to my questions. So we split you into 3 groups to then talk with either myself, Lorenzo, Celine. The groups didn't work kind of, there was no split in terms of, it wasn't like subject specific or issue specific, it was just a group that we thought would work. So we're going to have about 45 minutes then to talk in those groups. There are people who didn't write back to me, but don't worry, we're not going to throw you out of the room. We're going to keep you in here, which is nice.
Could you raise your hands if you haven't?
People haven't, yeah. How many people didn't manage to write back? Okay, so if you can, don't worry, it's not a big thing. We'll put you into groups. If you come and see me after we've read all the other names out, and we'll work out who goes to which group.
Good. Let's hear from the PhD.
We're going to say just a couple of words now, I think. We're going to do very quickly because I've got to take the taxi. We're then going to take you up to the Dirty Duck, which sounds more dodgy than it is. It's a pub on campus where we will buy you a drink and we'll leave you alone to then have a chat amongst yourselves. So some ideas I think that we're all going to say that come out of our little groups. But what we'd like you to do is think about organically so some things are just, you've met someone here that you will benefit from having more deeper conversations with because there's a research fit between you with interesting ideas. It doesn't have to involve us at all in the future ever. Great, go away, I'm glad we've got a catalyst for that. Secondly, though, if there are ideas that we're going to run through the ones that came out of our groups now, it would be great to get some more firmness around that. You've got a chance to go away and think about how you might network up in the future and how we might help you facilitate that. The 2 things we need, I think, in order to take things further are critical mass, so the more of you saying you want things, the more likely it is to happen, and some kind of leadership from within the kind of early career group, if you like. So someone who can help us to kind of transmit, to sort of communicate ideas back and forth, because you're closer to the experience of people in the group. Should we just quickly go and say what came out of our group then, and particularly kind of ideas for the future, I suppose? Yeah.
Lorenzo, do you want to go ahead?
No, please.
Okay. Well, this is just coming out from our group, but also after our conversations on the floor, that some people might appreciate a longer time, maybe like the long-term summer school, a few days, together, to have more of a conversation, a deeper engagement with the literature and the methodologies, and more sort of workshop-y thing, and perhaps, asking the SLSA if they would sponsor something like that. A network, I think that's pretty much what's coming out, that people would like to keep in touch with each other. So unless there are any objections, we will collate your emails and put it on a distribution list. Laura, you mentioned Slack as a possibility, as a communication mechanism. We might come back to you again. Anyone has used Slack? It's a it's a networking tool for professionals, which the IT services here use as well. But we can talk about that. But a network, we might come back to you on that Slack idea, or a series of workshops and meetings, maybe even a panel or something, a side event at the SLSA next year.
Yeah, I think similar things came out of our group, that sense of kind of maybe more intensive engagement and ability to be able to look at kind of methodological issues and approaches, translation of what you've learned at various academic conferences into your writing and share that. So that kind of, I think, deeper engagement and the kind of networking, whether it's organically, which is if you just met here on my golf and talk more, or the creation of some kind of more formal network. As I say, I'll re-emphasise those 2 points. The 2 critical things for us are critical mass. There's no point in setting up structure which no one inhabits. So we need to know from you that this is something that would be valuable to you. So please write it down on a piece of paper if we've given you. If it is, have you given out, Julie, you've given out a piece of paper now?
Yep.
Yeah, great. So you've got a piece of paper in front of you, which I'll explain in a moment. And then, as I say, some kind of, if someone within the group who's willing to take some kind of leadership there, that'd be great, because as we've seen with even knowledge of technologies that we might be utilising, but also the content of what people want to talk about, I think that would be very helpful for us. So I don't think, was there anything else that came out of our group on ideas for the future? I think it was similar, wasn't it, to what was discussed earlier? Yeah, right. Lorenzo.
We didn't get around discussing very much, but discussion was very much driven by the research interest of the group, and there was very good exchange around what different people are planning to do or doing, and the challenges they're grappling with, and there was, I thought, quite a bit of discussion, because some of the challenges were resonated, and so that was all quite positive. So perhaps, although we didn't touch on the next steps, it would seem to me, based on the discussion that we had, that this notion of creating a space where people can come together, perhaps with a little more time than we had this time round, and have that sort of space where you can exchange tips and exchange ideas on how to handle certain issues and how to tackle some challenges, that seems very, very valuable. So I think sort of once we make our plans and networks and Slack and all that sounds good.
Great, fantastic. So what we want to know from you now, you've got a piece of paper, a blank piece of paper, and you can write down whatever you want on it. That you think will be valuable to us. The 3 prompts I'll give you are, what did you enjoy today, what went well, what was valuable for you? We always want to know that. We always want to know what we should build on, repeat, etc., etc. What didn't work so well, what you thought was something that could be done different, better, because that's always incredibly valuable. And given the conversation we've just had, probably most importantly of all, how can we build on this in the future? What can we do that will really benefit you in terms of the idea we've had, so networks, workshops, conferences, those kind of things, and anything substantive you can say about what they should contain will be really helpful.
And if you want to play a role in taking this on, please put your name down. That's really important for us as well.
And so if you could do that now, we'll also write to you an email following on from this workshop to solicit any further views you've had after a drink in the pub. So this is not your final chance to say anything, but it's just the very first opportunity.
And thank you all very much for coming. I know that all of you have been, a lot of you have come from very far away. So thank you very much for taking the time.
Lorenzo's got to run and get a taxi so we can get transport back home. So can we just say a big thank you to him for coming down?